then you're going to go to prison, and you're not going to go to prison for 3 years. They're just there doing their jobs. If you follow the rules, they'll probably leave you alone. If not, their job is to make you follow the rules. And if you can't follow the rules in our jail, then I don't assume that you can follow the rules on probation, which you're kind of showing a pattern here. So it's time to grow up, change all that, or you're going to prison. It's that simple. And this is 23 DCCR 0639. Ms. Allen was placed on probation October of 2023 for evading arrest or detention with the use of a vehicle. In court, previously entered pleas of true and a motion to revoke probation to counts 1 through 10. I've received that updated pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
State has, Judge.
Are there any additions or corrections to that report?
None that I'm aware of, Judge.
Not from the state, Judge.
And this is unagreed. Mr.
Correct.
Parker, you may proceed.
Your Honor, all I can say is, these violations are all technical, even though, I understand that they're still serious and you have to follow the rules of probation. She's young. She's 19 years old. I think being in jail has opened her eyes, and she wants to complete probation. She has quite a bit of time behind this, and my deal was, take the time. She said, I don't want to do it. And she's sincere. She says, I want to prove to myself and prove to everybody else that I can complete this probation. And she has the opportunity. She has a job waiting for her. She gets out, and she's requesting this probation, and she'd like to address the court, Judge.
Go ahead, ma'am.
I just want to say I own up to all my wrongdoings. I do. I know it was wrong. I knew it was wrong when I was doing it, and I regret it, but I want to prove that I can do better, and I'm not the person that I got to be. I'm young. I want to build my relationship back up with my people, make it stronger, build my trust. Just do the right thing, make it right before it's too late.
Thank you, ma'am. Mr. Coleman?
Your Honor, this is Mr. Smith's case. I'm under the understanding that Mr. Smith made a 3-year offer in this case. I am cognizant of the fact that recommendations from probation department on the last page states that while the defendant's violations are mainly technical in nature, this officer is not inclined to recommend continuation of supervision at this time. So with that, my position is the same as Mr. Smith, that should be revoked and some jail time.
Ms. Lopez, do you have anything to add other than what's in the update? So, Ms. Allen, the only thing that I'm inclined to do if I continue, you are young. You don't have a lot of criminal history. This is your first felony, no misdemeanors. Of course, you're young, but you were actually certified as an adult for this, which is, I don't know, certifying on an evading is a little, I guess it's because she was so close to age, but still that's. So here's the thing. I'm not going to go home today. Okay. If I continue you on probation, which you don't want a felony conviction. At this age, it changes your life in a very negative way, but you obviously need some, in my opinion, just a little more help to make better decisions. And so what I'm going to do is find that you entered your pleas of true to counts 1 through 10 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and send you to prison. I'm not going to do that today. I'm going to continue you on probation, but I am going to order that you now enter and successfully complete the cognitive track of the ISF program. So you went to the substance abuse track so that you could get tools to stay clean. This track helps you make better decisions, helps you grow up. It's hard at 19 to make the decisions that you need to make to be able to stay on this probation, and this is meant to help you. And so you'll go from jail to that program, you'll get out, you're still going to be on probation. You will be on zero tolerance probation. That means if you make another mistake, Ms. Lopez is going to send something over. There's going to be another motion. I'm going to look back at this. Mr. Coleman and Mr. Smith are going to remind me that they asked for prison time this time, and it's probably not going to be the 3 years. Do you understand?
Yes,
I hope you take advantage of this opportunity. All right. Good luck to you, ma'am. You can go back with the bailiff. Come back for a second.
Jail.
Well, I just want to make sure of something else. I want to make sure you understand something else. That if you get incident reports in our jail or in ISF, that will be a violation of your probation. And you may not ever make it to ISF. So if you're going to say things to the correctional officers, not do what they say, and tell them that you don't care about getting a write-up, but say those things in a lot worse ways, then you're going to go to prison. And you're not going to go to prison for 3 years. They're just there doing their jobs. If you follow the rules, they'll probably leave you alone. If not, their job is to make you follow the rules. And if you can't follow the rules in our jail, then I don't assume that you can follow the rules on probation, which you're kind of showing a pattern here. So it's time to grow up, change all that, or you're going to prison. It's that simple. Understand? Okay, go back with the bailiff. I don't know how I did that. Okay. Bobby Clark, Mr. Parker.
It's rejection. Cheers. It's rejection. My wife's been home 24 hours in 4 weeks. She sent a text to one of our friends. I don't know when I'm coming back to New York. She's here. She's here.
You're like, hello.
I mean, being a bachelor's not easy. I'm telling you.
You're
I'm
gonna have
not
to.
very good at sitting at home by myself.
Yeah.
I have to go.
That's not a good thing either.
No.
Good morning. Are you Bobby Clark? Speak up, please.
Yes, ma'am.
And Mr. Clark, in cause number 25, DCCR 0802, you're charged with a second-degree felony offense of indecency with a child by sexual contact from March 10th of 2025. And what that means is if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand? And I have here on the computer a plea bargain rejection that you've signed with Mr. Parker. This shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 4-year term in prison. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that? Speak up.
Hold on just a second, Judge. Yeah, this is what I was,
Oh,
12.
I screwed up, Judge.
Wasn't 4, it was 12.
He had 4 here. It's 12 years. And I didn't, well, I'm assuming you're going to want to reject that.
Okay, so
But I didn't know.
I was wondering.
Yeah,
Make sure, no.
that makes sense. I was telling, I think it's a very good offer.
It was, yeah.
Yeah.
But that was, apparently that was his old case, and I didn't see down below where he.
Okay,
I didn't
so,
see the bold,
so Mr. Clark, the offer in your case is actually 12 years. And I'm assuming since you wanted to reject the 4 that you want to reject the 12. Is that correct?
Yes, ma'am.
And so again, I just want to make sure you understand the possible consequences if you go to trial and are found guilty. The punishment ranges between 2 and 20. The option right now is for a 12-year term in prison if you wanted to plead guilty. Do you understand? And do you want to reject that offer and have your case set for trial? All right, I will get that done. Is there any reason to believe that that offer would change? So I want to make sure also you understand that after today, unless there's some new information that comes up that the lawyers don't know about, I will not accept this plea agreement. You understand? Speak up, please.
Yes, ma'am.
Okay. And so, Mr. Clark, Mr. Parker has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint a new attorney who can begin preparation for trial a little quicker. Is that okay with you? So, Mr. Parker, you're released. Mr. Clark, we will appoint someone today. They should be out to see you very soon to begin preparation for trial. All right, you go back with the bailiff.
Thank you.
Mr. Matuska, Bonzel Hall. Morning. You working on the other one? Are you doing paperwork on Garner still? Huh?
We've got it, Judge.
Oh, y'all already done it?
Yes, ma'am.
Okay, I see. All right, perfect. Bonzel Hall.
I missed the opportunity to tell you, I told you so earlier. I really regret it.
Did you?
It was a cap and they got permission and we were booked today. Meant to.
You should, you got to take advantage of those
I know,
opportunities.
that's it.
I give them to y'all, so.
But it also would have been like Priscilla or maybe Ashley went by, so I didn't tell you, so. So I really shouldn't claim
It's okay. You're here for her. Good morning. Are you Bonzel Hall?
it.
And Mr. Hall is charged with the offense of murder in cause number 24, DCCR 1747. And what is the announcement?
Your Honor, we've received a plea bargain offer that we've been unable to reach an agreement on that offer.
Okay.
And I've informed Mr. Hall of that offer today. It actually has come down a bit. But, I've updated him on that. Again, we haven't been able to come to an agreement.
Okay.
And I see no reason why it would come down any further, Your Honor.
Is that a new rejection that
Yes,
you
Your
have? Okay. If y'all will sign that so I can get it over here and that way I have that. What's the offer?
It's 35 years.
So, Mr. Hall, if you don't want to take that offer of 35 years and you want your case to go to trial and let a jury decide, sign that document real quick and then we'll get it set for trial.
And Your Honor, this is not a cap. This is straight.
Okay. Well, your options are to take 35 years in prison or to go to trial.
So if I sign this, I'm accepting it?
No, if you sign that, that's the rejection that says you want to go to trial, but you don't want the 35 years. If you want to plead guilty and take the agreement for 35 years, there's some different paperwork y'all can do this morning and we'll get that taken care of. But if you don't want to take that offer, then we'll let a jury decide.
And I don't know if it's on that rejection, but I did discuss a possible 40-year cap of Mr. Matuska. If he wants to talk about that.
Do you want to talk?
I told you that.
So either you want to take the 35, take a 40-year cap and let me decide. I could give you 40, I could give you less, or let a jury decide if you're guilty and what your punishment is. That's your options.
You wanna reject that or discuss?
Take a 40-year cap.
Okay. Well,
Yeah, I'll go do that paperwork. I'll hold it for the paperwork then. So I'll delete this. Oh, wait, there wasn't anything. You can
No, they
delete it
hadn't
on your,
sent it
y'all
to me
hadn't
yet,
sent it yet.
so-
Okay, I'll hold it then. Let me, well, Mr. Matuska, I'll let you take care of that and then I'll do Garner in that one when you're finished. Get you all taken care of. Let's see. Ms. Holmes. I don't, oh, did he? Let's see. What was that on? Gabriel Smith. It's here. Mr. Kimler on Gabriel Smith. Gabriel Smith.
I think that's the one we did.
I know, I need to do the rejection.
Oh,
Yes, please, ma'am.
She looks
Okay, again, you're Gabrielle Smith. And Ms. Smith, and cause number 25, DCCR 0979, you're charged with a second-degree felony offense of assault on a peace officer from June 10th of 2023. And what that means is if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
Judge,
And I think-
nothing's been filed at this point, but I know with the number of priors she has and a note on the file that the priors have been ordered, I do anticipate there'll be a notice. I forget if it's Mr. Smith or Mr. Muffino, but I know they intend to enhance it.
So I want to make sure you also understand, and I'm going to make a notation on here. If any of those prior offenses out of Louisiana, the felonies, were at different times, and one conviction happened and then another conviction happened later, that means you could be considered a habitual offender and with a minimum punishment of 25 years in prison, up to 99 years or life in prison. Do you understand?
Yes, ma'am.
Also, just in case they're not one after the other, if you have one prior felony conviction, then, okay, it doesn't do anything. Right, this is a second. All right, so if you have two sequenced, it would make you habitual. Do you understand?
If she has one, it will boost her up to first.
Yes, sorry. So if you have one.
I'm not understanding what they mean.
Okay, so listen very carefully. You have several felony convictions out of Louisiana. Okay, so if just one of those is true, then your punishment range in this case, if you're found guilty, becomes that of a first-degree felony instead of a second. So that means it would be from 5 years minimum up to 99 years or life if there's one prior conviction. You understand? Answer out loud. So
Yes, ma'am.
okay. If there's two prior felony convictions that happened, not all of the, I know there were several that happened at the same time, right? But I'm not sure, but it looks like there might be another set that happened later. If that is true, and there are two that happened at different times, then it means you could be considered a habitual offender here in Texas. And if that all is true and you're found guilty, then your minimum punishment is 25 years in prison up to 99 years or life. Do you understand?
Yes, ma'am.
Okay. And it looks like what the state has offered, if you wanted to enter a plea of guilty, would be to go on count one, which is just the offense that you're charged with now, for an 8-year term in prison. You have every right to reject that and have your case go to a jury, let them decide if you're guilty or not, and then let them decide your punishment depending on what they find on those priors. I just want to make sure you understand what your options are if you wanted to plead guilty for that 8 years and what your possible consequences are if you go to trial. Do you understand all of that? Okay. And do you want to reject that offer and have your case set for trial?
Yeah, I want to reject.
Okay, and I do want to make sure you understand, Ms. Smith, that after today, unless there is new information or evidence that comes up that the attorneys don't know about at this time, I will not accept this plea agreement after today. So if you change your mind, it's not going to be to the 8 or something less later. It's going to be something different. Once a case goes on my trial docket, it goes to trial. So it's not we're buying time to try to get some better deal. This is the deal. That's fine that you don't want to take it. I do want to make sure.
I haven't, so I can't think on it and come back.
You can think on it and come back next week.
Okay, that's fine.
1 week, you'll leave it open?
Yes, Your Honor, I'll leave it open for.
You have to decide by next week, knowing all of that. Nothing's going to change between now and then. So now you know everything. Think about it. Talk to any family members that you need to. We'll have you brought back next week and you can decide, okay? I'm going to delete this rejection. If it if y'all do it again, you'll have to do it again. Okay? All of her, if you want to see that old PSI, it's got all those listed. We could get you a copy at least of that page, I'm sure.
I had a real question with Louisiana felonies and the judgments. Sometimes the judgments are problematic for Louisiana. It depends on which parish.
Okay. Well, y'all figure that out. Do you need more time than a
No,
week?
ma'am, that's fine.
Ms. Holmes, you're sitting over there so quiet in the corner. I didn't even see you. You've got LaKendris Addison.
Yeah.
Good morning. Let's see,
And
this
Judge,
is a motion.
we have an agreement on this case.
Okay,
On count one, I'm gonna drop January 2022, February 2022.
hold on half a second.
Oh,
Let me
sorry,
get that pulled up so I can make those. Okay. Count one.
And if it's okay with the court, we can proceed just on count one, but I was gonna drop the January of 2022 and February 2022. He was taken into custody in Louisiana during that time, Your Honor.
Okay, got you. Okay. Good morning. Are you LaKendris Addison? And Ms. Holmes, will your client waive the formal reading of the indictment?
He will, Your Honor.
I'm sorry, the motion.
Yes, ma'am. Yes, ma'am.
Mr. Addison, in cause number 21-36633, I have a motion to revoke your community supervision. Shows that you were placed on probation September 15th of 2021 for the offense of burglary of a habitation. And that was a 10-year term that was suspended and you were placed on probation for 10 years. Is that correct? And then count one alleges that you violated your probation and the state has amended that. Count one alleges that you failed to report as directed to the probation department October 5th, November 3rd, and December 2nd of 2021. And is that true or not true? True or not true? Count two alleges that, oh, I'm sorry, you going
If
on
it's
just
all right,
count one?
We can, Your Honor, if it's
Okay.
okay with you.
State abandons 2 through 5. Did you enter your plea of true to count one freely and voluntarily? And because it's actually true. I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand if I follow the agreement that you made with the district attorney, you'll be waiving or giving up any right to appeal? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Addison is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of true to count one freely and voluntarily. Find that count true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation. Reassess your punishment in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right, good luck to you, sir. You can go back with the bailiff.
Thank you, Your Honor.
Let's see. I gotta figure out how to do, the other day I figured out how to do a strike through. I gotta figure out how to do that again.
Ma'am.
Toy Hill.
Paying 35 miles a gallon.
Mhm. Good morning. Are you Toy Hill? And will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Hill, in cause number 25 DCCR 0650, you're charged with a third-degree felony offense of assault on a family member by impeding breath or circulation from January 24th of 2025. And how do you plead to that charge?
Guilty.
January, did I say February?
You said January 20th.
January 24th, 2025.
Yeah.
Is that, are you guilty or not guilty?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they've charged you with?
I did.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes.
And do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've made is for a 10-year term in prison, but that would be probated. You'd be on probation for 10 years.
Yes.
You would be ordered to pay a $500 fine and follow all of the rules and conditions of probation. Is that your understanding?
Yes.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Hill is not competent?
No, Your Honor.
All right, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Mr. Coleman, what is the state's position based on the nature of the plea agreement with regard to bond reduction?
Just for the court's information, I show a criminal history that includes a 4-year deferred on an injury to a child and a simultaneous violation of a protective order for 1 year probation, and assault, which was a misdemeanor, for resisting, and a theft, misdemeanor. I would have some concerns.
What is your relationship now with Cheryl Johnson?
That's our mother. It's real good.
Okay, so let me ask you this. If you are released, when you're released from custody, where will you live?
With a friend of mine, I'm in this client, 4555 Reed Road.
Reed?
Reed, R-E-E-D.
Uh-huh. And where's that? What city?
Off of, Highlands, it's off of Highlands, it's Reed Road, but it's in Beaumont, Texas.
It's in Beaumont. Because I want to make sure you understand that, at least for now, when you get out, you will not be able to have any contact with your mom, okay? And that's going to be very important, because if you do, if I let you out while we're waiting on the pre-sentence report and you have contact with her before we ever come back for sentencing, I don't have to accept this agreement, and things could be a lot worse. Do you understand? It's very important. So what I'm going to do, Ms. Hill, based on the plea agreement, is reduce your bond to $1,000. Okay, if you make that bond, you have a condition of that bond that you have to live at 4555 Reed Road with your friend. And if there's something changes and you need to live somewhere else, get with Ms. Holmes so that we know that. It is also a condition of that bond, if you make it, that you have absolutely no contact or communication with Cheryl Johnson. That means in person, obviously, but for now, that also means any contact, communication. Don't send her messages, don't text, don't email, don't Snapchat, don't, whatever it is, no contact. You understand? Okay. Even if she tries to say, it's okay, let's talk, I want to talk to you, you have to say no, because you're the one who will end up back in jail. Okay, so if for some reason you don't make that bond, probation will come talk to you at the jail, and then when you come back for sentencing, you would be released then. If you make that bond, then you also have to go straight to the probation department so they can do that report. So it's important that you do everything. They'll talk to you today and give you that information of where to go and all of that, okay? All right, you can go back with the bailiff. Can win, Ms. Holmes? You good over there? Good morning. Are you Can Win? Will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Wynn, in cause number 25 DCCR 0750, you're charged with the second-degree felony offense of burglary of a habitation from April 29th of 2025. And how do you plead to that charge? I'm sorry?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you reached is for an 8-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Do you understand? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Wynn is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Mr. Nichols, what's the state's position with regard to bond reduction?
There's quite a few misdemeanors, Your Honor, for burglary of vehicle and trespass, among a couple other things. We don't see any other felony cases. This burglary is against property owned by his mother. I don't believe it was her residence. I believe it was the place she owned. He went there and essentially stole TV. So I do have some concerns, but his criminal history is not particularly extensive, Your Honor.
Just sounds like it's some of the same things, though, that I have some.
Correct. It's mostly burglary, several burglary vehicle charges, several trespass charges.
All right, I'm not going to adjust the bond at this time, just in case I want to do something up front based on that misdemeanor history. All right, we'll get the pre-sentence report, and then you'll get sentenced at the next court date. You can go back with the bailiff.
Thank you, Your Honor.
Thank you. Two cases are called on Courtney Wiley. Those are both MTRPs. If you'll do the second one.
Judge, just so the court knows, because he was just asking, it looks, there's almost all of those misdemeanors are from about 15 years ago, except for a trespass last year.
Okay, come
So I
back.
just wanted to make the court aware of that.
All right, so here's what I'm going to do. Mr. Nguyen, I am going to reduce your bond in your case based on your plea agreement to $1,000. If you make that bond, a condition of it at this time is that you have no contact with your mom. Okay, you cannot go near her, any of her properties. Do you have a place to live? With your brother? Okay, so now there may be a time when you can have contact, but at this point, because she's the victim in this offense, you are to have no contact, no communication. Obviously, that means in person, but it also means sending messages or text or anything like that. Do you understand? And what'll happen if you make that bond is the very first thing you need to do is go straight to the probation department so that they can do that pre-sentence report. If you don't do that, then you run the risk of me not accepting the plea agreement and things could be worse. Do you understand? Okay, you can go back with the bailiff. You have both of them? Thanks. Okay, Courtney Wiley. Good morning. Are you Courtney Wiley?
Yes, ma'am.
And will your client waive the formal reading of the motion in each case?
Yes, Your Honor.
Ms. Wiley, in cause number 22-40872, I have a motion to revoke your community supervision. Excuse me. It shows that you were placed on probation March 1st of 2023 for the third-degree felony offense of harassment of a public servant in a correction or detention facility. And that was a 5-year sentence that was probated for 5 years. Is that correct?
Yes, ma'am.
And then in cause number 22-40873, I also have a motion to revoke your community supervision. This shows you were placed on probation March 1st of 2023 for the third-degree felony offense of evading arrest or detention with the use of a vehicle. That was also a 5-year sentence that was probated for 5 years. Is that correct?
Yes, ma'am.
Each of these cases allege that you violated your probation. Count 1 in each case alleges that you were arrested for the offense of public intoxication June 22nd of 2025 in Jefferson County. And is that true or not true?
Yes, ma'am, it's true.
See, that's another one. Count 2 alleges that you provided a urine sample June 23rd of 2025 that tested positive for cocaine and marijuana. Is that true or not true?
Yes, ma'am,
True or not true?
it's true.
Thank you. Count 3 alleges that you failed to comply with the program guidelines and rules of the Safe P Aftercare program. Is that true or not true?
Yes, ma'am, it's true.
And we can stop there, Your Honor.
Did you enter your pleas of truth, thank you, to counts 1, 2, and 3 freely and voluntarily?
Yes, ma'am, I did.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed those, did you go over them with Ms. Holmes?
Yes, I did.
And do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreements that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
State tender's number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Ms. Wiley is not competent?
No, Your Honor.
All right, ma'am, I'm going to find in each of your cases that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. In cause number 22-40872, find those counts true, find sufficient evidence to revoke your probation, and at this time, revoke your probation, reassess your punishment in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 22-40873, also find counts 1, 2, and 3 true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation. Reassess your punishment in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These 2 cases will run concurrently, which means together at the same time. I'm going to hand you in each of your cases the trial court certifications that shows that these were agreements that I followed, so you have waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes.
Okay.
Good luck to you, ma'am. You can go back with the bailiff. Latrick Williams, what are we doing on Latrick Williams?
Mike, one more time, that was Phillips, and I hadn't had a chance to talk to
Okay.
Phillips.
All right, I'll reset Latrick Williams, and if you need something and Philip's still out, just get with Ms. Malfino or Mr. Coleman or Mr. Nichols. I'm sure they can stand in and help you out with that if he's still out. Okay, Mr. Matuska on Bonzel Hall. Let's do him first. It may help me on Garner. Depends, the ones that he's pleading on Garner, it may be helpful for me since there's several to have the indictments printed, please. Okay, again, you're Bonzel Hall, correct? And will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Hall, in cause number 24, DCCR 1747, you're charged with the first-degree felony offense of murder, and that is from, hold on a second. August 10th of 2024. How do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Matuska? The papers on the computer that you just signed, did y'all go over those? Did he explain them to you? And do you understand them? And do you understand if I follow the agreement that you made with the district attorney that you'll be waiving or giving up any right to appeal? And it looks like y'all have decided not on the cap, but on the,
That's correct, Your
Okay.
Honor. And despite what he said earlier, we changed our mind to
Okay.
the original 35.
all right. Do you understand also, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1. It's admitted. Is there any evidence that Mr. Hall is not competent?
There you go.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of murder. Sentence you in accordance with your agreement to a term of 35 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Matuska. You also should thank Mr. Matuska because he worked out an excellent deal for you on this type of case. And I can assure you, if you had gone with the cap, things would have been a little bit worse. Do you understand? Go back with the bailiff. Xavier Garner. Oh, I just did it. Just made the noise. All right, there's 3 of them, it looks like.
We'll
Y'all got
have
'em?
3 cases, Your Honor.
Yeah,
It's only on 3 of them?
The others will be dismissals.
I'm sorry, 2324, I thought y'all could still see it. 2324 0890 and 0891. And then 2324 is the only other one I need, and also a copy of that sex offender registration, please, on that case. I can, actually, I got that, never mind. I just need the indictment. All right, are you Xavier Garner?
Yes, ma'am.
And Mr. Matuska, will your client waive the formal reading of the indictment in each case?
Yes, Your Honor.
Look at something real quick. Mr. Garner, in cause number 25 DCCR 0891, you're charged with a second-degree felony offense of robbery. And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with? In cause number 25 DCCR 0890, you're charged with a third-degree felony offense of obstruction or retaliation from June 3rd of 2025. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
And then finally, in cause number 24 DCCR 2324, you're charged with a second-degree felony offense of indecency with a child by sexual contact, 5th of 2019. And how do you plead to that charge?
Guilty. Guilty.
Again, are you pleading guilty freely and voluntarily,
Yes, ma'am.
and because you did what they charged you with?
Yes, ma'am.
In all three of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Matuska?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
And then finally, in 24 DCCR 2324, that's the indecency case, I have here a sex offender registration requirement form that looks like it has your signature with Mr. Matuska's. You understand that as a result of this plea, you will be required to register as a sex offender, right? All right, state tenders number 1 in all 3 cases.
No, Judge.
It's admitted in each case. Is there any evidence that Mr. Garner is not competent?
No, no.
All right, sir, I'm going to find in all 3 of your cases that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. In cause number 25 DCCR 0891, find sufficient evidence to find you guilty, and at this time find you guilty of the second-degree felony offense of robbery. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 25 DCCR 0890, also find sufficient evidence to find you guilty, and at this time find you guilty of the third-degree felony offense of obstruction or retaliation. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then finally, in cause number 24 DCCR 2324. Hold on just a second. We're going to go through this motion first, and then we'll figure out what to do from there, okay? Before we get started, I need you, the best you can, to raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thanks. It's okay. Mine's taking a long time too.
And I opened up the document.
It looks like there's a first amended maybe in both also. Or at least in,
I think both of them first.
okay.
Oh, yeah.
And will Ms. Butcher waive the formal reading of the motion in each case?
She will, yeah.
Okay. So Ms. Butcher, in cause number 24 DCCR 1732, I have a first amended motion to revoke your unadjudicated probation. Shows that you were placed on probation January 28th of 2025 for the offense of burglary of a habitation, a second degree felony, and that was a 10-year deferred probation. Is that correct?
Yes, ma'am.
And then in cause number 24, DCCR 1733, I also have a first amended motion to revoke your unadjudicated probation. Shows that you were placed on probation January 28th of 2025 for unauthorized use of a motor vehicle, a state jail felony, and that was a 5-year deferred probation as well. Is that correct?
Yes, ma'am.
Each of these motions allege that you violated your probation. Count 1 in each motion alleges that you failed to report as directed to the probation department March 7th, March 10th, and March 12th of 2025. And is that true or not true?
It's true, ma'am.
Count 2 in each case alleges that you failed to immediately report to the probation officer your change of address. And is that true or not true?
I don't have a change of address.
Okay, so not true. Count 3 in each case alleges that you failed to conduct yourself in a courteous and professional manner at all times when interacting with court officers and staff, probation officers, law enforcement officers, and attorneys. Is that true or not true?
No, ma'am.
Count 4 alleges that you were arrested for the offense of aggravated assault against a public servant, April 29th of 2025 in Harris County, Texas. And is that true or not true?
Yes, ma'am.
True or not true?
True.
Thank you. Count 5 in each case alleges that you were arrested for the offense of duty on, that can't be right.
I think it's a misdemeanor version of accident causing injury. So I don't know how it ought to be.
Duty?
It's,
Duty seems like the wrong word,
it
but
probably is, Your Honor.
something about striking an unattended vehicle on April 29th of 2025. Were you arrested for that also? So that's true.
Yes, it's true.
And count 6 in each of those cases also alleges that you were arrested for the offense of evading arrest or detention with the use of a vehicle, April 29th of 2025 in Harris County, Texas. Is that true or not true?
True.
Count 7 in each case alleges that you failed to remain in Jefferson County as ordered and that you were in Harris County, Texas, April 29th of 2025 without permission. Is that true or not true?
That's true.
Did you enter your pleas of true in each case to counts 1, 4, 5, 6, and 7 freely and voluntarily? And did you plead true to those counts because they're actually true? Okay. All right, I'm going to find that you entered your pleas of true to counts 1, 4, 5, 6, and 7 in each case freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. However, I'm going to reset your case so that the probation department can do an updated pre-sentence report. That'll give me more information about you, your cases, and what is going on in Harris County. And then we will come back later for a sentencing hearing. Obviously, the state can bring any witnesses with regard to 2 and 3 if you'd like, Mr. Nichols, at that time. Okay. So,
I have a question.
yes, ma'am.
There's no way you can waive the PSI. Everything is still the same, ain't nothing changed. And I was sentenced in Harris County to 5 years deferred probation, and they want me to go to rehab. I have a hold right now because I have to go to Santa Maria for 6 to 18 months. And I want to know, can you please waive the rehab and allow me to be transferred to Harris County so I can start rehab before my baby gets here?
So here's what I can do. I have to get that info, not that I don't believe you, but I need to get that information. When are you due?
November, the end of November.
Okay, so can we get an expedited update? Maybe a couple of weeks? Is that possible? Okay, so I'm going to reset the case for 2 weeks, and that way probation can get with Harris County. We can figure out what exactly went on in those cases, and then I'll determine what to do, because I'm not telling you right now that I'm going to go along with all of that. I mean, you're on 2 felony probations and it sounds like you've already pled guilty to several other serious ones. Hang on. Just, I don't want you to, I'm going to get the information. I'm going to see what they did, whatever rehab and all of that. And then I will decide on that day if I'm going to go along with that. Okay. All right. So we'll see you back in 2 weeks. Yes, ma'am.
And Judge, it's a transportation code section that's titled duty
It's so weird.
on striking structure, fixture, duty on striking unattended vehicles.
Duty on.
That's just how they title this section. And so it's really a failure of that duty is the crime, I guess.
Right. It's just a weird word to use. Maybe there's a definition of duty that I don't know. You said duty? I said duty. You keep saying duty. Sorry. How many times can you say duty? Mr. Rojas, you have Roderick Randall. I thought we needed that. This is very. Oh, there we go. It was just stuck on something. It's okay. Good morning. Are you Roderick Randall?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the motion?
Here we are.
Mr. Randall, in clause number 24, DCCR 0543, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation October 7th of 2024 for the offense of aggravated robbery, a first-degree felony, and you were placed on a 5-year deferred probation. Is that correct? Speak up.
Yes,
This motion alleges that you violated your probation. Count 1 alleges that you were arrested for the offense of unlawfully carrying a weapon on May 3rd of 2025. And is that true or not true?
True.
Count 2 alleges that you were arrested for the offense of evading arrest or detention May 3rd of 2025. And is that true or not true?
True.
Count 3 alleges that you possessed a drug, marijuana, May 3rd of 2025. And is that true or not true? Count 4 alleges that you failed to provide verification of completing community service hours. Is that true or not true?
True.
Count 5 alleges that you did not provide verification of entering and successfully completing the anger management program. And is that true or not true?
Judge, count 6 is duplicative of one of the other accounts. We can abandon 6.
Okay, state abandoned 6. Count 7 alleges that you failed to provide verification of attending a drug and alcohol awareness course. Is that true or not true? Count 8 alleges that you failed to abstain from the use of any and all intoxicating substances, including alcohol, and that you provided a urine sample April 2nd of 2025 that tested positive for marijuana. And is that true or not true?
True.
And then count 9 alleges that you're behind in your court assessed fees. And is that true or not true? Did you enter your pleas of true to counts 1, 2, 4, 5, 7, 8, and 9 freely and voluntarily? And did you plead true to those counts because they're actually true?
Yes.
And so I have some documents here on the computer that have your signature on them that shows that it looks like you've made an agreement for me to continue your probation and send you to ISF cognitive track. Is that your understanding?
Yes, ma'am. Judge, I realize it's troubling that he's committing misdemeanors and has a gun on him when he's on probation for aggravated robbery. I also know that the court could sentence him up to life for 99 for violating his probation. So this, to me, appears to be a one opportunity for him to get his life right before he's locked up for most of it.
So here's what I want to do. I want to get an updated report. I want a little more information about that new
Certainly.
offense, the PC and some things like that. And then I'll decide if I'm going to go along with this when we come back at sentencing. So I am going to reset the case for sentencing. I want to get more information about those new offenses and what's been going on, and then I'll determine whether or not I'll follow that agreement. It appears, at least for now, that you don't have any substantial, is there any?
There's
Anything?
one very minor,
Okay.
write-up that was provided today for horseplay from
Okay.
myself, Judge.
So it's very important that I don't have a stack of incident reports in front of me when you come back. It looks like you've been doing well. It is very important that you continue to do that because that could influence me one way or the other as well. Okay? All right, we can go back with the bailiff.
Yeah, I think it is. Yeah.
Mr. Kimler, you've got Nathan Lamel. Two cases.
You got to plead not guilty to the offenses. See about getting a bond set.
Good morning. Did you file anything for a bond?
Yeah, I've filed a motion for a speedy.
So he's gonna enter some pleas in the motion, and then what about the new case?
New case is pleaded not true. And if there's administrative things, we can go through that. I think that they've been doing a lot of prosecution. Or is it
Computers.
It's not my case, I'm just standing in for,
Ms.
Peter
Murphy.
Ashford. Yes, that's from, I can't speak to what she intends to do.
I'm sorry, my screen is still loading. There. Is everybody's spinning? Oh,
I don't see a motion for a bond. We'd ask for 3 days. I'm not prepared to report on that advance notice.
Should have requested one in the letter, if not the motion itself, on the notice letter.
Request for probation bond and speedy hearing
Revocation hearing, yes, sure.
was filed August 18th. Let me just go through this motion
It's
first.
the same one I always filed.
Mr. You're Nathan Lamel? Mr. Lamel, best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. You can put your hand down. Will he waive the formal reading of the motion?
So I'm just gonna go through it.
All right, Mr. Lamel, in cause number 24 DCCR 0826, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation February 17th of 2025 for the offense of evading arrest or detention with the use of a vehicle, third-degree felony, and that was a 5-year deferred probation. Is that correct? This motion alleges that you violated your probation. Count 1 alleges that you were arrested for the offense of burglary of a habitation, April 26th of 2025. And is that true or not true? You weren't
Well, he
arrested?
was arrested, but
That's what the allegation is. And I'm not, anyway, y'all, I don't know why they've changed them to just arrested, because being arrested isn't really a violation instead of committing the offense. All of a sudden, all these motions are different. Y'all might want to take a look at that. They're not alleging that they committed the offense.
I apologize, Your Honor. He was arrested, so that would be true, but I don't think it's a violation.
All right, so count one, you're pleading true to? Okay.
You were arrested.
Count two alleges that you failed to avoid injurious or vicious habits as directed. I don't know what count two is either. No, just don't worry about it because it doesn't say what it was. And so I don't think that is an accurate, I don't think I can go forward on count two. Count three alleges that you failed to report to the probation office March 5th and April 9th of 2025. And is that true or not true? Count three is true. Count four.
Just to be clear, I think what he said was it's true that he called in. So I don't know that he was.
Did you report or did you not report on March 5th or April 9th?
I'm not sure.
I think what he said was you didn't report, but you called in.
I don't need to know that. I need to know if you reported as directed on March 5th and April 9th of 2025.
Full plea contrary. I think he's not sure.
Count four alleges that you provided a urine sample May 1st of 2025 that tested positive for tetrahydrocannabinol. Is that true or not true? That's marijuana, THC. Did you test positive on May 1st? Speak up.
Not sure.
Okay.
Not true.
Count five alleges that you were at a location other than your residence at 3:01 a.m. on April 26th of 2025. And is that true or not true? Count six alleges that you tested positive on May 1st of 2025 for alcohol. And is that true or not true?
Not true.
Did you enter your pleas of true to counts 1 and 5 freely and voluntarily? And because those two counts are actually true. All right, then I'm going to find that you entered your pleas of true to counts 1 and 5 freely and voluntarily. Find those counts true. Find sufficient evidence.
I think you pled not true, not to 5.
1 and 5?
That's my understanding.
He
That's what I wrote
pled,
down.
No, 5 is 3:01 a.m. I thought he said,
Not true.
not true.
I wrote down not true.
oh, I'm sorry.
He's
So,
only played true to number one.
Right.
okay, so you're saying that is not true that you were at a location other than your residence at 3 o'clock in the morning on April 26th?
When you were arrested, that was your residence or wasn't your residence?
Oh, that was my reason.
He's saying it was his residence that he was
That's what I was
arrested at,
saying.
what he was saying. So it's not true.
Okay, count 1 then. All right. So I'm going to reset your case for a sentencing hearing. Obviously, the state can bring any evidence with regard to the allegations that you pled not true to. Also, y'all might want to make a note, go through if there's going to be any amended motions. Looks like I've seen several like this that need to be addressed.
Yes, ma'am.
It doesn't appear that the offense is alleged, Your Honor,
It's not at this point, correct?
but there's a non-prosecution file for that.
That's-
so
I don't-
may be
that's-
part of it.
All right, so we'll get an updated pre-sentence report in this case. And so Mr. Kimler filed a request asking that I set a bond in this case. Give me just a second before I get into that to go. I'm going to take a look, for the record, I'm going to take a look at the probable cause affidavit and cause number 25 DCCR 0744, which is that new case. So give me just a minute. Yes, ma'am, it's unagreed. printed it. It's easier for me to read in person. Mr. Kimler, do you have any evidence with regard to that bond?
His ability to post the bond, Your Honor, is that what you mean?
Yeah, any evidence with regard to your request for a bond?
Well, just that he's on, I believe he's on deferred and, what's your financial situation? Not too good, you employed, or did you lose your job because of your arrest?
I had a job that I lost you all for the rest.
Where were you working?
I had just started. Doing that.
I can't, if I, don't make me tell you to speak up again.
I would just say he doesn't appear to be an absconder, Your Honor, and it's just a few days. It seemed to be.
Well, my issue, I mean, regardless, I guess at this point, until we have more information about whether or not the complaining witness is going to go forward, is that it appears as though
Domestic dispute, Your Honor.
well, he had already been trespassed, warned by the officer, I believe that same day, left with his mother, and then the allegation is he came back and then was aggressive with officers. And that the allegation is that there was a broken a window that was broken and coming through a window, so that doesn't.
She's not I think the victim, the alleged victim's present, Your Honor, if you want to.
I renew the state's position that we weren't prepared to go forward. In fact, on the bond today, in fact, there's a copy of that letter that Mr. Kimler references. You may have a copy there, but I don't have a copy filed. We asked for at least a couple of days to.
Did you just send that to us, or did you e-file it?
It was e-filed, I don't know if she
and-
tagged, I mean, I don't do that.
You got to make sure they have notice of that. So at this point, what I'm going to do, hold on just a second.
She is present. though.
And we're not prepared to go forward.
Yeah, but they haven't talked to her or prepared for anything.
I don't understand why they didn't get a copy of the motion that's been filed.
Well, it was
It wasn't a motion.
a
No, there's motion.
letter.
There's a motion filed.
We have neither a motion or a letter in file.
Well, that's their problem, Your Honor. I mean, that's not mine. He's in jail. And, I mean,
Well, if it was e-filed and sent to the correct people, then I don't know that it's necessarily their problem or an electronic problem or a problem that your office didn't send it to the right person. So we're not,
But it was e-filed. My point is it's on file with the clerk. It's on file.
the state has to be aware of it. Just hang on a second. I see that he's in jail. It's a jail docket. I also have some concerns whether she's here or not with what was going on, because just because she says she doesn't want to prosecute doesn't mean that I think she's safe with him doing what this allegation is after he was trespass warned from going over there. Yeah, I guess when you do need to make sure, I guess I have it from the 18th, a request for reasonable probation bond and speedy probation hearing comes now, blah, 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 asking for it. An order was attached as well. So somewhere it got either lost or something wasn't done correctly one way or the other. Doesn't matter at this point. We're here. My bigger issue is probably the same issue that the state's going to have. I want them to have time to talk to her. If she's going to file something and it changes the status of this, then we'll deal with that at that time.
she has filed a non-prosecution.
You have that in the file? Okay.
Just, and one final thing I'll say on this is, it's one thing to e-file something, but it's a whole nother thing to make sure that you hit the tab or
I've gotten there too.
Yeah,
I've already
initiate
said,
service.
I understand, and that's what I'm saying. If the right service wasn't sent, then it's an issue on your side that they didn't get it. Make sure it's done correctly,
To Ashley. I mean, you can see on the e-file notification.
that it was sent to her.
To Ashley.
Okay, so it was sent. Is it gonna show up here? It says it was,
Let me show you. This is what he filed in the original case, and then they re-indicted the case in the bond, switched over to that one.
so can we get this to show up now in the original? I mean, in the new case?
I can ask, him to either redo it, or I can, yes, ma'am, I can get it in there.
Okay,
I will do that.
okay, let's see. You are Gabrielle Smith? Stand up, please. And this is cause number 25, DCCR 0979. Ms. Smith is charged with assault on a peace officer from June 10th of 2023. And Mr. Kimler has filed a motion asking that I reduce the bond, which is currently at $40,000, correct? Ms. Smith, the best you can, raise your right hand. Do you swear or affirm the other one? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. Go ahead, Mr. Kimler.
Gabrielle, what are your financial resources right now before trying to post a bond?
Speak up where I can hear you.
Well, I have one.
Hang on a second. I need everybody to keep it down, please, because I'm having trouble hearing. Speak loud and clear.
I have one family member that could probably help me, but I don't have one. I've been in jail a year, so really nothing.
How long?
A year.
A year. And is that waiting to go to trial?
And yes, sir. Just here. Ready to give my charges, I guess, decided.
Do you think that you could host a $5,000 bond?
Yes, sir.
Can I see, has the other case been dismissed? Can I open that one up and see what all's been filed in it?
Two, three, yeah, that 2,3D, 1030.
Like, such a big copy, didn't I want to say? Okay, let's see.
Every time something happens.
So it looks like okay, there was back in February of 2024, there was a bond forfeiture. So the bond was raised because of that. Then it looks like there was a motion for me to reduce the bond, which I did. In October of 2024, I reduced the bond to $10,000. And then
She did enter the plea, Your Honor. You
Entered-
said PSI bond.
I did
That
at
plea was
one-
Rejected by the court.
Okay. The bond was reduced to 1,000. There was a plea. And then
So there's a plea and then it was reduced, I guess.
for PSI, I reduced it to 1,000. And then appears as though in February of this year, I'm trying to figure out exactly why I increased it to 40,000. Hold on, let me just figure out.
Sufficient.
Okay. And then, let's see, let me look at this PSI, that'll give me some information. So the agreement was for a cap of 5 years, which is unusual that I would have reduced that to $1,000. So I'm not sure I understand why I did that in the first place when it was a cap, but I did for some reason. And that pre-sentence report,
Court
She-
revealed 9 convictions, felony convictions from Louisiana, Your Honor. That's why you rejected that.
right, and several misdemeanor thefts and a revocation. Been to prison in Louisiana. Yeah, as recently as 18. Okay, so I rejected that plea agreement. So the bond is currently set at 40,000 on a robbery with that criminal history. Okay. Mr. Nichols, what is your position with regard to bond?
With her criminal history and the allegations in this case of assaulting an officer while she was trying to steal from a store, I think 40,000 is right where it needs to be, Your Honor.
Mr. Kimler?
I've read the probable cause affidavit. I don't think that she could actually be said that she actually assaulted the officer directly. There is a fact situation that could perhaps be fitted into an assault charge. But as far as just out and out striking or assaulting an officer, that wasn't the fact scenario. Involved a vehicle. I think the officer had leaned into it and then the vehicle went into motion. And,
Well, how did the vehicle go into motion?
well, that's the defense, I suppose.
Hold on, let me look at the PC.
Well, it's not like she hit an officer or hit an officer.
She scratched at him while he was trying to stop her driver from trying to leave, Judge.
She was flailing about, I suppose.
So over here in a car with a paper tag from Louisiana, which is where all the other criminal history is. That motion's denied.
Okay, we've got a speedy trial, I guess, so we need to try.
We're in the 252nd, everything's speedy.
All right,
It will be placed, I mean, is it? It wasn't on the trial docket. I mean, if you want to do a rejection, if you've done all
Well,
the,
I guess if the court has rejected the plea offer, then the 5-year cap.
do y'all want to negotiate any other? Do you want me to just move it to the trial?
Take 8.
Take 8. You want me to do a rejection?
And still be.
Yeah, if you'll do a rejection of whatever that offer is, that way I have a paper trail of why it's on the trial docket. Goodness gracious. Mr. Matuska, you've got Xavier Garner.
Yes, Your Honor.
6 cases. Oh, I don't have, hold on, let me recall that in just a second. Do you have some stuff coming through on Garner? I've got a registration, but I don't have anything else. All right.
And then I'll need the title, Judge, up in here.
Okay, that's okay. I'll hold it for just a second. Thank you. That's gonna be a good one. Get rid of 6 cases. Mr. Parker, you've got Jacoby Judge.
remember what I've done on
No, I just looked up and I've got a line of things ready, which is good. Yeah. Good morning. Are you Jacoby Judge?
Yes, ma'am.
And will your client waive the formal reading of the motion?
He will, Your Honor.
Mr. Judge, in cause number 24 DCCR 1174, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation September 17th of 2024 for the offense of obstruction or retaliation, a third-degree felony, and that was a 3-year deferred probation. Is that correct?
Yes, ma'am.
It alleges that you violated your probation. Count 1 alleges that you failed to provide verification of attending the SafeP program. Is that true or not true?
True.
And then count 2 alleges that you failed to successfully complete the SafeP program. Good grief. These are a mess.
I don't know why they phrase them like that, Judge. I mean,
All right.
He did it twice.
Okay.
But-
You didn't complete the SafeP, you didn't complete the SafeP program, right?
No.
Okay. Did you enter your pleas of true to counts 1 and 2 freely and voluntarily?
Yes, ma'am.
And because those counts are actually true?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number
No
1.
objection?
It's admitted. Is there any evidence that Mr. Judge is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1 and 2 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time, find you guilty of obstruction or retaliation and sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
Yes, ma'am.
I've handed you the trial court certification that shows these were agreements that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker.
Yes.
All right? Good luck to you, sir. You can go back with the bailiff.
It's on there. It's not real now.
Warren Mills.
Judge, I'm
Mr.
gonna ask, we reset that a couple weeks. We've had issues with the video. I've got the video and I need to go with him. He wants to talk to his
Okay.
family.
All right. We'll just do maybe about 3 weeks on
That's fine.
Mills.
Bertrand, I believe.
Shaniqua Washington.
Bertrand, Delaney.
Morning.
Shaniqua.
Good morning. Are you Shaniqua Washington?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment?
Sure, Your Honor.
Ms. Washington, in cause number 24, DCCR 2370, you're charged with the state jail felony offense of theft with previous theft convictions, and that's from September 29th of 2024. The indictment alleges you were previously convicted of theft April 7th of 2010 and then again July 12th of 2012. And how do you plead to that charge? And are those two prior convictions true? Did you enter your plea of guilty freely and voluntarily? And because you actually did what they charged you with? Did you plead guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? And do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement is for a deferred probation. How long?
3 years.
I'm sorry. Can y'all, any problem with me writing that in?
I wrote it. Well, maybe
didn't-
she
it
probably
didn't come
sent it.
through.
She sent it before.
3 years. Okay, so a 3-year deferred probation, a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Is there any restitution, or were the items
They were recovered.
recovered? Okay. Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number
No
1.
objection.
It's admitted. Is there any evidence that Ms. Washington's not
No,
competent?
you're right.
Other than those 2 that are listed, do you see other issues?
Judge, I see nothing but misdemeanors, so she's got misdemeanor history.
Okay,
We're asking waive the DSI.
We're okay with waiving it, or if the court wants one, we're okay with a PR bond.
yeah, I mean, if yours,
There is
This-
history.
there is, I mean, the last one that's listed here is 2012,
We've got some other charges other than.
That's misdemeanor.
other than this. Okay, all right, then I'm going to waive the pre-sentence report. I'm going to find that you entered your plea of guilty freely and voluntarily. Find, did I print that? Do I need to do it again? I might not have. Okay, going to find sufficient evidence to find that you enter your plea freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings, place you on probation for 3 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And at the end of the probation period, the case will actually be dismissed if you're successful. The other side of that, though, is if you violate any condition of probation, you can be brought back into court. You could be found guilty, so you would be a convicted felon, and you could go to the state jail prison for up to 2 years. Do you understand? All right, I'm handing you the trial court certification. That shows this was an agreement that I followed, so you waived your right to appeal. Probation's going to talk to you before you leave today. It's very important that as soon as you get out, you do everything that they're tell you to do, okay? All right, good luck to you, ma'am. Let's see, Kendrick Williams, 4 cases are called, Mr. Parker.
Kendrick Williams.
Your cases are gonna be on there, whatever on this day, just stay, just ignore it, you don't need to, we're working on it right now.
Okay, so we've
I
got,
didn't write CC on these cases, Judge, but
okay. That's fine. And are we going on, are there more than one count? Are we going on?
On the
I
motion,
did
Your Honor,
second degree.
No, are they all
Well, the
new
state jail
cases?
that's enhanced and
the state jail requires its enhancements.
That's the possession?
Yes, sir.
I-
Well, there's 2
I'm-
possessions, Your Honor.
I'm thinking about it.
No,
I may-
the evading arrest and previous convictions.
I'm just now thinking I may have filled out the state jail paperwork wrong. I'm not positive, but I may have.
Just be patient with me as I pull it, and then I'll
Yeah.
figure out what we need to do, if anything. Okay, are you Kendrick Williams?
Yes, ma'am.
And will your client waive the formal reading of the indictments and also the motion?
He will, Your Honor.
Okay, so there are priors listed, so it is count 1. I'm assuming,
Yes, Your Honor.
at least on the 1075.
But it's not needed. 1075 or 2352.
Okay, just 1076 today.
Yes, Your Honor.
Okay. In cause number 24, DCCR 1075, the state has elected to proceed on count one only. It alleges you committed the second-degree felony offense of possession of a controlled substance from February 19th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And because you did what they charged you with? Okay. Give me just a second. In cause number 24, DCCR 1076, you're charged with a state jail felony offense of evading arrest or detention with previous convictions. And is he getting state jail time on
No,
this?
that's what I think. I
So we
filled it.
need all of them.
Yes.
Did you do state jail paperwork?
I don't remember. I'm thinking I've had in state jail paperwork. I've got this one up here. I've redone it, but I just don't remember if I did or not.
Okay. So the offense date on this is from February 19th of 2024. The indictment alleges you were previously convicted of evading arrest or detention September 26th of 2007. It further alleges that you were previously convicted of possession of a controlled substance, a state jail felony, September 24th of 2007, and also possession of a controlled substance, a state jail felony, September 4th of 2012. And how do you plead to that charge? And are all of those prior offenses convictions true?
Yes, ma'am.
Okay, let me make that note real quick. This is so much better than paper. Okay, and then in cause number 24, DCCR 2352, you're charged with the second-degree felony offense of injury to a child, elderly, or disabled individual from July 19th of 2024. So that's already a second. Are we going on the other counts as well,
We
or
don't
no?
need to, Your Honor, just count one.
So in that count one only, how do you plead to that charge?
Guilty.
And again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with? In all three of those cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1 in those 3 cases.
No objection, Judge.
It's admitted in each of those cases. Is there any evidence that Mr. Williams is not competent?
No, Your Honor.
All right, Mr. Williams, in cause number 24 DCCR 1075, I'm going to find that you entered your plea of guilty freely and voluntarily. find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of possession of a controlled substance. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. You did it right.
I did?
Mhm.
Okay.
And cause number 24, DCCR 1076, I'm also going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. And in that case, find you guilty and find those prior convictions true. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 24, DCCR 2352, also find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of injury to a child, elderly, or disabled individual. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Now, let me get the MTRP pulled up.
And Judge, counts 1 and 2 include some of the cases we just pled to. The third one was not yet added as an amendment, but since we had an agreement, we just go on 1 and 2.
1 and 2, okay. All right, and cause number 21, 36841. I have a motion to revoke your community supervision. It shows that you were placed on probation October 13th of 2021 for the offense of assault on a peace officer. And that was a 10-year term in prison that was probated for 10 years. Is that correct?
Yes, ma'am.
It alleges that you violated your probation. Count 1 alleges that you committed the offense that we've already talked about of evading arrest or detention with previous convictions, February 19th of 2024. And is that true or not true?
Yes, ma'am. Sure.
And then count 2 alleges that you committed the offense of possession of a controlled substance, February 19th of 2024. And is that true or not true?
Sure.
Did you enter your pleas of true to counts 1 and 2 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're both actually true?
Yes, ma'am.
I also have here on the computer in that case some documents that have your signature on them that the state's marked as exhibit number 1. Did you also go over these papers with Mr. Parker?
Yes, ma'am.
And do you fully understand them also? And you understand if I follow this agreement, you will be waiving your right to appeal.
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. All right, sir, I'm going to find that you entered your pleas of true to counts 1 and 2 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You'll also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. You will, these cases will all run concurrently, which means together at the same time. I'm going to hand you the trial court certifications in each of these cases that shows that these were agreements that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right? Good luck to you, sir. You can go back with the bailiff.
Thank you, Your Honor.
Thank y'all. What you need? Y'all need some? Yeah, I can just give me this.
Yeah, he don't, new cases invited.
Okay. Bailiffs already know. Okay.
Damn.
It's reset if he's here. Just.
Amanda Arendt.
Judge, that's, the state is asking that we reset that. This is Ms. Maltino's case. She's trying to talk to somebody about, I don't know, to give me an offer.
Okay,
She's asked us to reset.
we'll just do one normal reset on that. Kyla Allen, it's a sentencing, Mr. Parker.
Yes, Your Honor. What I do? No, she can go back. I told you already. Kyla Allen.
This courtroom hearing takes a serious turn when Tina Sally appears before the court for sentencing after pleading guilty to 2 felony offenses: simple possession of methamphetamine and felony bail jumping. What makes the hearing especially complicated is that the original drug charge was amended from possession with intent to deliver down to simple possession. The state explains that the amount of methamphetamine involved was extremely small, and the allegation involved Sally offering the substance to another person at her workplace. The defense emphasizes that there was no money exchanged and no evidence presented that Sally was actively dealing drugs. Before accepting the pleas, the judge carefully goes through Sally's rights and makes sure she understands exactly what she is giving up. She confirms that her attorney reviewed the paperwork with her, explained the possible penalties, and discussed her constitutional rights. The judge explains that the felony bail jumping charge could carry up to 6 years in prison and a $10,000 fine, while the possession charge could carry up to 3.5 years and another $10,000 fine. Sally confirms that she understands the consequences and still wants to plead guilty. Once the guilty pleas are accepted, both sides present their sentencing recommendations. The state argues that probation is appropriate, but points out that Sally was already on felony bail when the new conduct occurred. The prosecution recommends conditions including drug treatment, avoiding illegal substances and drug paraphernalia, staying away from known drug users or dealers except in treatment settings, and obtaining a valid driver's license. The defense asks for a shorter period of probation,